Hi, this is Michael Feigen, Esquire. I am a patent and trademark attorney. You can find me online at patentlawny.com or patentlawNJ.com. I'm licensed in New York, New Jersey, and the U.S. Patent and Trademark Office. I handle patents and trademarks, throughout the country and worldwide. And today we're going to talk about an overview of trademarks. So, what is a trademark? And an overview of the trademark system. What is a patent? An overview of the patent system. And then we're going to talk in more detail about patents. First, we're going to talk about preparing to file a patent, what you need to do to prepare to get the patent application ready and to file it at the U.S. Patent Office, and then actually filing it in that process. And what happens at the U.S. Patent Office. So we'll go through obtaining the patent from beginning to end, from preparation, filing, to actually getting the patent. So let's begin with the overview and introduction. So my background is in IT and biological sciences, and I've drafted many patent applications for large phone companies, internet startups, that sort of thing. You can take a look at them on my website, again, patentlawny.com. And my firm began in 2007, and I've been doing it since then. So, been doing it before then, but my firm began in 2007. Let's go into protectable types of intellectual property. There are basically 4 types of intellectual property. The first type is patents, which are what people generally call inventions. It's any new and useful process, machine, manufacture, composition of matter, or any new and useful improvements thereof. So patents protect more or less a new and unobvious idea. What's new, what's unobvious? Well, what's new is usually easy. You either find what person puts in the claims or not. What's obvious is a little bit more tricky because obviousness is sort of defined by the user. Do you consider this obvious or not? So we have all sorts of legal tests and words to try and define it. You need some sort of mental leap or some sort of something more. It's not obvious to try. That when you try it, it has unanticipated results. That type of thing. Generally, what it boils down to is finding one feature that's not found in anything else and putting that in a claim of a patent. Trademarks are to identify products or services to consumers. So it is something that designates a unique source. So like Coca-Cola doesn't really represent their formulation or what was new and obvious about the first person to make the cola formula. But what it does represent is that when I buy Coca-Cola, I know I'm getting a product from the Coca-Cola company. I know who it's coming from, and they have control over what they put in the bottle. Theoretically, they can choose to put something totally new in the bottle. Well, they did that once. There was new Coke, and people didn't like it. But they have the ability to use their trademark how they want. As long as they police it and keep other people from using it, then they retain basically that right to police it and keep other people from using it. Copyrights are works of authorship reduced to tangible means of expression. So a copyright is someone does a sculpture, a new piece of art they draw, a new literature, a movie, whatever it is. Where it gets interesting is the overlap between these 3 is where if you have a long-form piece of art, it's a copyright if you have a whole work. If you have a title of a work, well, it's probably nothing, but a title of a work, if you have a series of titles, so the Internet for Dummies series of books, those are trademarks. I am not committing trademark infringement by mentioning these names, by the way. I am merely referring to them, and that's what a trademark is for, so the public can refer to a product by a new name. That's what a trademark covers. Then we also have design patents, which protect the look of a functional object. So a functional object can be protected based on how it looks with what's called the design patent, even though the artistic characteristics of it would be protected by a copyright. Trade secret is finally the 4th type, which is a secret protected with legal rights, which you would contract with a person. You would contract with a person and say, hey, you want to work for my company? These are our trade secrets. You are not allowed to disclose them to others, but other people can reverse engineer them. One of the most well-known cases of reverse engineering is the BIOS, the Basic Input and Output System, which was developed by IBM. And they weren't exactly the smartest with how they developed the computer for many reasons. It was off-the-shelf parts, and the IBM computer was wildly successful, and we're still using derivatives of it. But the only thing which was really proprietary in it was the BIOS, how the parts of the computer communicate with each other, the programming that was done to do that. That was kept as a trade secret. So Compaq went, and they basically reverse engineered how it was done. It's an interesting story, which I'm not going to get into in detail right now, but they reverse engineered the BIOS. They came out with the Compaq computer. It was the first, or one of the first laptops, and the thing was huge. It was like 35 pounds, but they called it a laptop at the time. And they were able to sell clones, and a couple of years ago, IBM actually sold the whole business to another company in China, not profiting from it anymore. So things might have turned out differently. If it wasn't open, maybe it wouldn't be as widely used, and that system had gained as much wide recognition as the IBM-type computers have today. But on the other hand, maybe they'd make more money, so that's always the debate. They'd get a good number of years out of it. Okay, let's go on to now trademarks. So we're going to talk solely about trademarks in this next part of the presentation. So a trademark is a word, a name, a slogan, a symbol, a sound, a smell, a color, and that's not even exhaustive. Anything else that's used to indicate a unique source of the goods. There are actually, you can go into the trademark office, you can actually download sound trademarks. I'm going to give you an example of one. Actually, no, you know what? I'm not going to give you an example of one because I'm not going to take the risk that it is infringement. But if you go onto the trademark office website, you can see, for example, the THX sound, which is famous, the NBC jingle, those types of things. The siren. There's a standard siren which is protected since the 1950s. That sort of whir of the siren as it gets louder and softer. That siren is actually protected by, I believe, American Signal Corporation, and it has been so for a good 60 years, and they maintain that trademark. More common examples might be, as I mentioned earlier, Coca-Cola or M&M's, those type of things. IBM is a trademark. Specific shade of green for laundry board was once actually protected. I've protected service marks for companies. For example, I have an insurance company where I protected his trademark. If you're buying insurance from another company, then we're both losing money. That whole slogan is protected. Anyone else uses that, they can be sued for infringement. So a service mark, let's get into that. A service mark is the same as a trademark, but instead of identifying goods, it identifies a service. What happens, practically speaking, is at the trademark office, when you file a trademark application, you select the goods, or you put onto, for those people who still use paper applications, you write your goods on your paper application, or you can type it into the electronic form, or you can select it from the trademark manual and simply put it on, and they will tell you what classes that it's in, or you, again, write what classes it's in. So, for example, class 25 is a very popular one for clothing, so that would be a trademark for 25. In class 25. However, class 41, if you're selling retail goods, that is now a service mark for the goods that you are selling. So they really function the same way, except one identifies a service, one identifies goods. What is trademarkable? We'll go on to this topic. Things which are trademarkable, there must be no likelihood of confusion. The corollary to that is if somebody does something on the market which is likely to confuse with your trademark, then we call that trademark infringement. So we only allow trademarks to be registered if it's not confusingly similar to what's out there, and we figure out what is trademark infringement by it being confusing. So, for example, if you have a trademark for, let's use a well-known example, IBM, and you are selling, let's say they're still selling computers, and there is somebody else, and you try and register a trademark for IBN, N as in Nancy instead of M as in Mary, then that is probably going to be confusingly similar if your goods are computers. But now suppose you trademark IBM, M as in Mary, and your trademark is for auto parts. Well, there might be an association there because IBM is such a famous mark, but if it was IBN as in Nancy instead of M as in Mary and it's computer parts, or auto parts, I'm sorry, not computer parts, it's auto parts, then there's not going to be confusing. It's not going to be confusion. Why wouldn't there be a likelihood of confusion there? Because not only is the word different, but also the goods are different so as not to confuse. That is the typical two-step test that the Trademark Office uses when they examine trademarks. How close are the goods, and how close are the words in their look and sound and that sort of thing, that sort of appeal. However, there are two famous cases which are often cited here. One's known as Polaroid, the other one's known as Sleekcraft, and these are basically cases that spell out the likelihood of confusion test in a 13-step test. I'm not going to go into all 13 steps, but suffice to say, it has to do with steps that you would define as confusingly similar. It depends, are they the same class of goods, or the same type of goods, same channels of commerce, does it sound the same, how sophisticated are the consumers, are they going to be really sophisticated to realize the difference, is it going to be an impulse buy where they're not going to notice till afterwards. It's a good case about that. Steinway pianos versus Steinweg pianos. In this case, the person would realize only after they walked into the store they're buying the wrong piano. In the first instance, they thought they were going to Steinway, and they walked in, they realized, hey, wait, these aren't Steinway pianos, they're Steinweg, but they buy them anyway. So that was called initial interest confusion. That was actually my paper in law school, which is why I'm fond of the topic of initial interest confusion. You can read all about it on my website, patentlawny.com. In terms of where we draw the line, this comes up quite frequently in internet cases where people might see a website or a URL that looks like a similar name but isn't, and then they'll realize if it's cheap goods like Rolex, well, they probably won't bother going after them for the real cheap goods because it's not worth it and they abound. But if they're real expensive goods, then that's where it gets to be a problem. If there's another Rolex company with watches just as expensive, I don't know why people buy them, but that's a different story, then that would be a problem. Because now a person's going to realize it's another company, but hey, they're great quality. That's where the companies really worry. It's not where the cheap knockoffs, people know what cheap knockoffs are, but where it looks like the real thing, that's where it's a problem. And it must be a name which doesn't refer to a common product out there. If it does, you can't get the trademark, or if it becomes so, you can lose the trademark. Famous example of this is Kleenex, or Xerox. People call tissues Kleenexes. They called copy machines Xeroxes. Now Google goes out of its way to tell you that Google is a brand name. Searching is not called Googling. Searching is called searching. You are searching on Google because they want to differentiate Google from the generic word, because otherwise they can lose the mark. So too, on the other side, if you try and register a mark, and the mark you're registering, suppose your name is chocolate chip cookie, and you're selling chocolate chip cookies, you can't get that. I have another example, remote landlord. Remote landlord is descriptive. You don't exactly know what it is, but it describes what the goods are. So for that, there's something called the supplemental register. Supplemental register will allow you registration on the trademark system. You get that nice R with the circle, but you cannot get statutory damages and things of that sort. You can only get actual damages that you can prove. You can't get legal fees and so forth. After a mark is in use for 5 years, or you've spent a heck of a lot of money on it, then you can get it on the primary register. Another example, the look of Chanel bags. They actually spent, I saw on one of their trademarks, they said that they spent $30 million in advertising the look of a bag, or the pattern on the bag. So normally this would be considered on the supplemental register. People don't automatically recognize it as a trademark. Till after 5 years of use, the trademark system says, okay, you're using it for 5 years, then we'll recognize that. We'll say that people recognize it as a trademark de facto after 5 years. Chanel went and said, hey, we spent $30 million advertising the look of this bag. Come on, that's enough to make people recognize it. Trademark Office said, yeah, okay, we agree. And they allowed it on the primary register. So trademarks are often all about money. It's money to protect them. It's money to get your mark out there. Money to advertise them. That is, it actually makes sense. That is what makes a trademark. That is what makes something recognized, is by teaching consumers what the word is. You want to be good to teach them that this is your word, but you don't want to be too good in which your word becomes synonymous with what it's doing, because now it is not a trademark. Now anybody can use it. It's that middle road that you want to be in. And the other problem is that Clients tend to want words which are descriptive. Attorneys, if you go to a marketing department of a company, they tend to want words that are descriptive. People recognize it already. You don't have to spend as much marketing dollars on it. But if you go to their legal department, they'll say, you're going to give us a huge headache protecting this mark. Let's have an arbitrary mark. Let's make it, my favorite is Meebo, which was bought out by Google incidentally, or Google for that point. These are arbitrary words which really have nothing to do with what's being sold. So in that way, they're easier to protect. All right, now we're going to go on to trademark clearance searches. Trademark Office typically only searches trademark registrations. It's really not enough. You might get a trademark registration that way, even because they haven't found what's out there, but you might be setting yourself up for an opposition or just an unenforceable trademark. If you're 5 or 10 years down the road in a business and you want to expand and you find you can't because it turns out there's another user with that name, you have a problem. Famous example of this is Burger King. Burger King, the national chain store of, well, we'll call it food, this company, they have expanded their restaurants, fast food joints, whatever we'll call them, all over the country. However, it turned out there was a prior user of the Burger King name. It was one solo restaurant somewhere in the middle of the country, and they went to court over this, and Burger King, the big corporation, has the mark everywhere except for within a 20-mile radius of this store. The other Burger King, this one restaurant that predated them, has that name within their 20-mile radius where the corporate chain cannot enter. So that is an atypical result. The typical result is one party spends the other into oblivion, and that is the end of that. Further, you can generally find these things a little more easily because you can do a full clearance search. Full clearance search is more than just searching the trademark office or what's registered. You search business records, and you do sound X searches for anything related, and it searches now websites and that sort of things, and yellow page listings, and state registrations, and corporate registrations, wherever someone's registered an LLC or C Corp around the country, and that type of thing, to really find out if a name is clear. I find oftentimes clients don't want to do these for one simple reason. They cost more money. However, it is a good idea and something that any serious person should be doing to really make sure that their mark is clear, with the few exceptions. There are exceptions where a person's just got such a crazy name that if they're calling themselves Mishkabobble and they're selling roses, well, I think they're probably safe registering that mark. Someone who is listening to this, feel free to prove me wrong and show me where there's some 11-year-old kid selling roses under the name Mishkabobble, and, I will retract that statement. Now, the trademark federal registration. When we register trademarks, it is good throughout the country. This is why trademark registrations are so cool, because it is one federal system. There are state systems, but they just put anything you file onto there. But the federal system is throughout the entire country, and it trumps any state registration. And you can now get a lot of damages. You can get attorney's fees, you can get statutory damages, which are quite high. I have actually done this, you can notify Google and YouTube and eBay and so forth of your trademark, and you can go and tell them, look, I got a registered trademark. Please stop these people from using my trademark. They are not allowed to do that. There are instances where there are, and a referential use and that sort of thing. But they will not look at you, they will not want to hear from you unless you have a registered trademark. Otherwise, they're not going to sit there acting as judges and figure out who's who and sort it all out. That's what the trademark registration system is. When you have a trademark in the Federal Register, it's presumed to be proper, it's presumed to be valid, and a reputable company will honor this. It is also a very good way to get copycats from stopping. If somebody is infringing upon you, it's a much harder case if you don't have a registration. You say, well, I've been in business 20 years and I had this name. If you have a registration, I've been in business 20 years and I got the trademark to prove it. Now it's much better. That's basically the government's stamp of approval that, yes, you've been in business for 20 years using this name, and you maintained it. It takes 6 months to a year and a half or so to register your trademark. It's really more about 9 months to a year and a half to be more realistic. And you need to show that you're using it between the 5th and 6th year, and between every 10 years minus 1. So between the 9th and 10th, 19th and 20th, 29th and 30th, and you keep registering you keep renewing your trademarks. And that is all we're going to cover on trademarks today. If you have any more questions on trademarks, I'll probably give a future lecture going into more details on just trademarks, or again, feel free to look at my website where you can see a timeline, patentlawny.com/trademark-timeline. You can see a trademark timeline for the process. And now we will go into the next section on patents. Patents are where we're going to spend the bulk of today's lecture. And the first section is, what is a patent? So, what is a patent? It's very simple. Well, it's not so simple. A patent is any new and useful creation. It has to be new, useful, unobvious. It's got to be what the layman calls an invention. Now that definition is kind of broad because now we allow business methods and new methods of doing things. For example, I always like to give this example. U.S. patent number 7,203,674 issued April 10th, 2007. This is a method and system to connect and match users in an electronic dating system. So, what's claimed, I'm going to translate this from patentese, which is a special language sort of like, I don't know, Klingon or something that only patent attorneys understand. It sort of resembles English. But anyway, here it is in English language. Step 1, establish real-time communications between two daters on the computers for a certain amount of time. Step 2, ask the user if they want to date again. Step 3, re-establish real-time communication. This is speed dating. They successfully patented the concept of speed dating on the computer. Basically, you open the video conference and you speed date. This patent, so I heard from someone who was trying to sell a license to a company, and instead the potential licensee took from this company, was worth a lot of money. We're talking, it was a 6-figure first down payment plus a royalty that was ongoing for its usage and how much this dating site was making off of doing it. So it can be a lot of money if you can get such things patented. Other types of things that are patented, design patents again, it protects the look. For example, I've patented rings, warming mats, electric candles, tables and chairs, and all sorts of different things the way they look. Mechanical things, cylindrical puzzles, hand sanitizer, the way it works, inversibly selected indicia, software patents. I have image recognition to manipulate a hardware device. That one I'm proud of. That was pretty cool. You actually take all the images, you manipulate all the images, and you recognize where the boxes are that you check, and you enter data and stuff, and you create a common interface on one computer. You're actually manipulating, could be 15 different software programs on 8 different computers to do all that automatically from one location. And electrical things, one client does a lot of ground penetrating radar. I've done RFID things, RFID bingo game, that was a fun one. Mark Cuban actually drew me a cat about that one. If you don't get my reference to Mark Cuban drawing me a cat, well, Shark Tank, I've seen every episode. And you can see the cat that Mark Cuban drew me, again, on my website, patentlawny.com. You can also read about it. I got a whole big article about the cat that Mark Cuban was kind enough to draw for me. That's my claim to fame, is that Mark Cuban drew me a cat. Oh, and I get to give CLE courses to other attorneys. That's kind of fun too, but I don't know, the Mark Cuban cat thing, just better conversation piece than giving CLE courses. Anyway, that's enough about cats. The source of the right. So this comes from Article 1, Section 1, Clause 8 of the U.S. Constitution. Congress shall have the power to, quote, promote the progress of science and useful arts by securing for limited times to inventors and their inventions exclusive rights to their inventions and their discoveries. Okay, I flubbed the last part. I don't have the whole thing memorized. I apologize. But in any case, point being, patents, as well as copyrights, in fact, are in the Constitution itself. Thomas Jefferson is said to have drafted these clauses, and the original statute, which was put into law, basically follows this. It's changed minorly in 1952, I believe, but it's more or less as Thomas Jefferson drafted it. more or less really hasn't been changed for one or two reasons. One, it was really drafted well and there's no reason to change it. Why fix something that isn't broken? Or two, have you seen the effectiveness of Congress to do anything? I don't think they're going to get around to changing this anytime soon. Alright, any case. So, 35 U.S.C. 101. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, any new and useful improvement thereof, may obtain a patent therefor. It is pretty broad. Well, except then they add this little subject to the conditions and requirements of this title. That's where it gets hairy. The conditions and requirements of these titles are probably 5,000 pages long. I'm going to give you a brief overview. 35 U.S.C. 112. Inventor gives to the public. How do you make this thing? How do you use it? What's the best mode of making it? Basically, you inventor, you tell the public exactly what you did. We want to know everything, so we can take this, we can copy it, we can do whatever we want with it. I can go and look at, say, a patent from now 21 years ago that's expired. That would be, in the 1980s, and I can go and look at what year is it? Okay, 1990s. That's scary. I can look at a patent in the 1990s already, and I can look at the original patents in the web browser and sort of that type of thing. And what came out in the 1990s? What was his name? Vanilla Ice? Alright, whatever. I can look at things from the early 90s, and I can, so my associate over here is laughing, listening to me record this, and I can copy those things now because it's out in the public, and hopefully advance technology that way. The inventor, on the other hand, what does he get for giving up his rights to this? Well, he gets a very selfish right. Being selfish, it moves people. It makes people go forward. It's basically the whole idea behind the capitalist system and why communism failed. So he gets the ability to make it, sell it, use it, and import it. So basically, he gets an exclusive thing. He basically says, hey, you, U.S. government, you're a monopoly. You know what? I want to use your courts, you monopoly. You have power over everything in this land. You can dictate who does what. Well, subject to the Constitution and your interpretation of it, depending on if you're Scalia or Ginsburg. But in any case, he says, I'm going to use this government right, and I am going to use this mafia to go break the legs of anybody who goes and tries to copy my idea. And the U.S. government says, hey buddy, sure, I'll do that for you. Just one thing. Costs you a lot of money. Just give me your money, you buy your protection fee. That's basically a very good analogy to how it works. You pay the government a lot of money. You say to them, hey, here's my protection fee. And they, as the mafia having control over the businesses in their area, go and say, yeah, okay, fine. So here, I accept your protection fee. Now you pay me even more money because now someone copies you. You pay me even more money to do that. And here's what the capitalist system is great. Not only does the government take its money, the lawyers take much, much more money because we're in a capitalist system where the individuals get to make money off of this stuff too, off anything and everything. Anyway, that's enough of my, let's just say, mafia comparisons between mafia and government. There's many positive aspects too, like even though the United States government is, has lots of inefficiencies and lots of big problems, it's the best one in the world. It's the best we got. So, I'm going with it. I'm sticking with it. Love you, American government. Okay. Patents are valuable. And I love the fact that the American government lets me say that. How amazing is that? Okay. Patents are valuable. Why? So, again, government, monopoly on world power, they can redistribute the wealth, they can take away your liberty, they take away another person's liberty to copy your thing. That's good news for you. Intellectual property, so now you are creating this property. You took, instead of this 100-acre homestead granted to you by the government, you took this 100-acre patent. Your 100 acres, someone encroaches on it, you can't shoot them. You're not allowed to shoot them, but you can sue them. We go for the purse here. Everything's about the purse. Everything's about money. We can take money out of people so they don't have to beat each other up in the streets. That's what we do. So your exclusive use of your invention deters others from even entering the market. Why does it deter them? Because, hey, you got a patent. Forget it. I'll go where there's lower hanging fruit. Why should I mess with this person who's got a 10-foot electric fence and guard dogs around what he's selling? Instead, I'll go mess with the guy who doesn't. I'll just go take his thing and take his property. I'll go onto his land, I'll take his oranges and sell them over here. because he's got no protection. No protection equals, hey, it's freedom. We're allowed to do whatever we want. You didn't protect it. It's mine. I can take it. That's more or less the way ideas work. All right, investors, they want to see IP. I can't tell you how many times I have clients that I'll tell, this is not patentable, and they say, well, I need it because I need to raise money. Okay, we'll file the patent. All right. And we try and put something through and try and get something. This lecture is coming out way too cynical. All right, we'll try and make a little more upbeat from here in. Helps establish your brand as being the original and genuine vision. All right, there we go. There's the positive reason. That's your original version. This is you. You're the real one. It's a big marketing thing. Say, hey, this is patented. And hey, you may just deserve it. You really got a cool idea. It's really yours. No one else should steal it. Protect it. Now you can stop infringers, and you can even stop them from bringing it into the border. You can also license your invention to others. How cool is that? You've now created a right that you can license to others. I created this cool thing, but it costs $10 billion to bring it to market. I can't do it because I don't have the money, but I can go and license this to General Electric, and they will then go and do it, and they will pay me royalties, and I get to keep my check, and isn't that wonderful? So, now we go to actually preparing and filing an actual patent application. How do I do that? Well, first you keep your trade secret. First rule of patents, don't tell anyone anything. File it. The United States, Canada, Australia, some other countries, those are the big ones, will give you a 1-year grace period from the time you make it public until you file it. Don't do it. It's not worth it. Sometimes people do it. Better to file, get your first filing date. The United States, like just about, I think, every country in the world, is now a first-to-file system. The first one to file gets the rights. File early and often. Rest of the world gives you no grace period. If you make a disclosure before you file it, you have a problem. All right, maintain confidentiality. Use confidentiality agreements with attorney-client. There's already privilege, there's already confidentiality. You go to a lawyer and you say, I just shot someone. He doesn't go, oh crap, it's a murderer here in my office. I have to call the police. No, he says, okay, here's my retainer agreement, sign, give me money. Because he must represent you, unless you're clear and present danger and that sort of thing. Hey, that might count for the attorney ethics portion of this lecture. You can put down 0.1 hours of attorney ethics that you received in this lecture. So, my associate is laughing again. You have privilege and confidentiality. I refer people to where they can look me up at the state bars, and where the U.S. Patent Office, you can look me up there. Or you just plain old sign a retainer agreement with them. I do not, as a matter of course, sign other people's confidentiality agreements. Reason being, you have to disclose certain things. For example, there is a duty to disclose, quote, all references which are material to the examination of the patent application. Australia used to have a similar requirement, just dumped it. United States is the only country left that I know of that has this requirement. Basically, it means you found something, you have to disclose it to the patent office. Patent office finds something, they put it on the record too. You're supposed to then have negotiations and figure out what you claim based on those. Oftentimes it's more adversarial than that, but you have this duty to disclose, and because you have this duty to disclose, you do not want to sign a confidentiality agreement where you are potentially violating it because you have a duty to disclose. Rather, if you look at my engagement agreement, which anyone's welcome to look at patentlawny.com/NEW, that's the word new for new clients, over there I have my engagement agreement, and I actually have links to the federal statutes. I actually go to the Federal Register where it says these are the duties that a patent attorney has, maintain confidentiality, disclose certain things at certain times, that type of thing, and I say here, sign that electronically, or if you really insist on being so 2002, we'll do it on paper. And then we have such an agreement for the paranoid inventor, and most of them are. Keep records to determine misappropriation, data conception, due diligence, that type of thing. It's not as important today now that we're first to file system, but it's probably still a good idea. And generally we say things like, do you want to invest in a better mousetrap? We don't say things like, hey, do you want to invest in a mousetrap that has this little laser that shoots at 0.3 milliwatts and shoots the guy in the eye and blinds him and then hits him over the head with the back end of the laser. That would be too specific. Just say you want to invent a better mousetrap when you're talking to a person about if they think the idea is good or not. Okay, types of patents. We have design patents, protects an ornamental design for an ornamental article of manufacture. is 14 years. They are very narrowly protected. It protects against somebody who thinks that it is the ordinary observer who thinks that it's the same thing. It's 14 years from date of issue as opposed to utility patent, which is 20 years from date of filing. Utility patent is anything new and obvious under the sun made by man, which is a messed up version of what King Solomon had written in Ecclesiastes or Koheles, which said that there is nothing new under the sun made by man, but okay, Supreme Court kind of made their own version of it. So the argument between what is new and what is not new, what's made by man, you get into philosophical debates. They're fun philosophical debates. I enjoy them. I have articles about them on my website. I'm not going to get into the philosophical debate about what is abstract and what is not, and the law on that changes roughly every 10 years as the Supreme Court or the Court of Appeals Federal Circuit gives us a new legal test on what's abstract, what's a law of nature, what's a natural phenomena, and then the U.S. Patent Office uses some sort of rigid guidelines on this anyway, and after they apply the rigid guidelines for too long, and we have too many stupid patents or not enough patents, then they go and change the test anyway to make roughly the right number, because trying to put a definition on the line between abstract and non-abstract is next to impossible. I'm going to say is impossible. If anyone wants to challenge that on me, please do so. I love to have these arguments. Okay, plant patent, it protects a new breed of plant. Do not ask me about plants. I do patents in New York and New Jersey. Nobody has ever come to me with a plant patent. One time, my associate in Pennsylvania had a question about a plant patent, but that was about as far as it went.
XSMCLE control number 6-13-13.
Now, going to more detail. When an invention is patentable, it must be useful. Just about anything. Does it kill the weeds? It's useful. Does it help the weeds grow? It's useful. Is it novel? No one has ever sent a bunch of messages as dots and dashes before. Hey, that's novel. Non-obvious. That's Morse code, by the way. Non-obvious. No one in the right mind would date on the internet, so if you're the first person to patent the concept of dating on the internet, then that is non-obvious. Somehow it became obvious now and widespread, which baffles my mind sometimes. I probably shouldn't speak because I met my wife partially through using an online system, but it involved real humans selecting the people and matching them up to you just using the database online. But okay, that's a different story. Be happy to argue over dating methods as well. Our dating methods that we have in this world are generally worse than our government systems, but we won't get into that either. What is patentable? Process. Method of routing calls to an IP phone, that's a good process. Machine, device for receiving calls connected to an IP network, hey, that's patentable. Manufacturer, black box that you can punch out holes, release one for one network port, sure, that thing of manufacture is good. Composition of matter, a mixture of 95% synthetic fiber and 5% kryptonite, that would be a good composition of matter. Kryptonite, by the way, kryptonite doesn't exist. Krypton does exist. And any combinations of the above. If you make a combination of the above, which is new and unobvious, you now have something patentable. Okay, now we're on to filing a patent. Yay, filing a patent. So, we're going to go through the process. We are now a first-to-file system. This changed as of March 16th. That means that on March 16th, when we changed from the first to invent to the first to file system, and the government raised its fees tremendously, that there was a deluge of people filing patent applications. I found a way to avoid get out of the system a little, where what they did is now this new system is if you are a micro entity, if your client earns less than $150,000 a year, and they have filed less than 4 United States non-provisional patent applications, they receive a reduced fee. That reduced fee is to the detriment of everyone who's filed more than 4 patents or earns more than $150,000 a year. The old fee used to be usually $533 for utility patent application. If you qualify as micro-entity, again, less than 4 previous non-provisional patents filed and your income less than $150,000, which will change each year. It's 6 times the median income for the prior year is how they determine it. Right now it's $150,000. We have a little bit of inflation, so that That threshold will probably go up a little bit each year. Anyway, if you now meet that micro entity, the fee dropped from $533 to $400. If you don't, it increased from $533 to $730. Now, if you went and filed it before May 16th, you get the first to invent. And if you didn't pay the government fees and you were filing for a micro entity, they get to pay $400 in fees plus a $40 late fee. I believe it's $40, so they actually end up paying less and get the best of both worlds. Well, it's too late to do that now, but it is an interesting way of gaming the system. So, now patent attorneys get to ask all their clients, hey, by the way, what's your income? I find it rather impolite to do. You now have to ask people, what's your income? Sometimes you can kind of guess. The doctor living in Manhattan has to have much more than $150,000 to even afford to live there. Where in contrary to that is if you have the retired real estate agent, then their income in almost all cases is going to be less than $150,000 a year. So you can kind of guess and kind of figure out how to bring it up. On the upside, when a client says, I don't have money for this, come on, I'm just really trying, I really want to do this, can you give me a lower price? Well, you can now find out if they're telling you the truth or not, or at least have a better idea because they have to disclose to you what their income is to get that lower price. So it is a gift to a patent office, but it is a socially inappropriate gift given to the patent office. So, that covers the prices, and first the file system is rather simple. You file it, you have a filing date, good. If you didn't file it, bad. So you can now, the problem is this. Suppose you're developing the system and it's not yet ready. Well, there's a provisional application for that. You now have to take whatever you want. Well, you always could do this. You take whatever you want, you put it in a provisional application, slap a cover sheet on it, and that gives you a filing date at the patent office. People do this. They say, hey, now I have patent pending. All it does is it reserves your right to file a non-provisional. Within 1 year, you now file the non-provisional application, and now it can claim priority back to your original filing date. You preserve your filing date. That's all you're doing. And it only preserves your filing date for what's disclosed in your provisional, not for things you didn't disclose, which makes fun arguments. The only requirement, other than meeting the cover sheet and paper size, that sort of thing, is that it must be enabling. So it must enable one of ordinary skill in the art to carry out the invention. It can create more litigation issues. What's in there? You will pay the practitioner twice. You'll pay patent office fees twice. And that sort of thing, but if you really need a filing date quick, that is the way to get one. Alright, next we are on to novelty searches. Basically it works like this. There's a school of thought that says, file a patent without doing any searching. Why? You gotta disclose it. You have to disclose to the patent office what you found. The other school of thought is, that's ridiculous. You need to know what's out there. What's the point of filing something in the dark? I don't know there's an elephant in front of me, but I am going to develop a gun to shoot elephants. Well, if you don't know what it is in front of you and develop a gun to shoot elephants, then you go and try and shoot it, it turns out to be a rhinoceros. It turns out to have really cool armor, and your gun is totally useless against it, and it comes and charges you, and you die. It's an extreme example, but that's what happens to patents. You file a patent and you have no idea what's out there, and it turns out there's another patent out there that's really exactly the same or covers it. Well, you would have known that beforehand and saved your client from wasting a ton of money. And or you would then talk to your client and you'd actually develop something patentable. You'd work around it. You'd find ways of putting different terminology, different features, different aspects into the patent application when you file it, and might actually get your client a patent, in which case he is what? Happy. Truth is, clients are happy as long as they think you're doing a good job. That's what's important in this industry. Your client has to think you're doing a good job even if you don't get the patent. Not every patent goes through. You get search results, and that from the patent office, they may come back with more things. You get an obstinate examiner, and the client just doesn't want to keep paying. So these sort of things happen, even if you are right and the examiner is nuts. So in that case, you can file appeals, you can do all sorts of things, but it is expensive. So what we generally do, we search patents first, and we find what's out there. We search the class and subclass of the patent office. For example, class 2 is apparel. Class, say, I don't know, I'm making this up, 27 is bracelets. Then class 705 is business methods. 379 is telecommunications. Those are common ones I work in, which is why I'm familiar with them. And you find the closest patents and patent applications sometimes that are in these classes, and you give the person a report saying, hey, is this thing actually patentable? Alright. So, and not only that, it familiarizes both the practitioner and the client with existing technology. And you also know what your competition is doing. Now, we get to preparing a patent. So first thing you do when you prepare a patent is you make a disclosure to the practitioner. I got to know what it is. What is it you want to patent? Guy called me up today and said, somebody called me. Okay, who are you? Oh, maybe you called my brother. Did you call my brother? Who's your brother? That's kind of the equivalent of what I get sometimes where people say, I want to patent this thing. I want to patent a screenless TV. Okay, how are you going to do it? I don't know. But if they go and tell me I want to patent a wand which goes back and forth at really high speed, better than any other wand that goes back and forth at really high speed because I'm going to do it in such and such a manner, now we're talking. Once I understand the details of how it works, then there's something to patent. So, telephone and live conferences, I use Skype for my worldwide clients, and sometimes for my clients 20 minutes away that prefer to do that. That sort of thing, and we get to understand the technology. And then we discuss possible ways of working it around. We draft claims, up to 20 of them. We want to make it as broad as possible to cover every different feature. And in case claim 1 is rejected, we have claim 2, 3, and 4, which will then usually claim sub-features of them, more detailed, that sort of thing. We draft a complete specification with background, summary, detailed description, and claims and everything. And we put together a full patent application. You can take a look at, for example, just to run through one of them recently issued. If you look at, you can do the caller ID unmasking patent, known as trap call in the industry. You can see this trapcall.com. If you actually look at the patent, you can again find it on my website, patentlawny.com. This is patent number 8369501. If you look on the first page, it has the title, System and Method for Providing Caller Information to a Called Party Using Call Forwarding, the inventor's name, the assignee name, application number, when it was filed, all that other fun stuff. You'll see everything that was cited by me and as in this that I found in the search, as well as the patent office. And then you will find there an abstract, which is a short paragraph describing the invention. You'll describe figures, which in this case are mostly flowcharts showing how it works. And after those fun flowcharts, you get the text of the patent, which has the field of the invention, the background, where it talks about ANI, automatic number identification, and how it's used, and caller ID, and how we're doing a combination of the two to take a call which you receive, send it to voicemail, which really forwards to an 800 number, reveals the number using a protocol called ANI, which has been out there from AT&T since the 50s, populates the caller ID data on a return call back to the original caller, and then after we do the background, that wasn't background by the way, we have the summary, which basically says what I just said, description of the drawings, and detailed description application. Finally, at the bottom, last page, second to last page, and last page, you can see the claims, which is what is actually being claimed in the invention. Once you go through that, then we submit this to the patent office. When I first started doing this, the fee was $462. The fee now is actually lower for some. It's now $400. It's higher for others. It's now $730 for them. You submit declarations signed by the inventors, information disclosure statement, assignment documents to assign rights from the inventor to companies, because in the United States, patents always go to the inventors. And once you're doing that from, say, 15 to 50 months later, you get a first office action on the merits. That first office action on the merits, generally, the examiner reviews the prior art and issues a rejection. It's just the way the system works. If you file a claim with your healthcare company, they generally will issue a rejection. They'll say, sorry, no good, not going to cover that. So, same thing with the patent office. Then you talk to the examiner, you tell him why his rejection doesn't make sense, or what's different, or you amend your claims, and you try and get around it. The reasons it could be rejected is 1, 35 USC 101, there's no utility here. You claim something abstract. You tried to claim ball lightning. You tried to claim a method of knowing God. You can't know God because you are not infinite. So that type of thing is considered abstract. We need something which is a tangible concept. 35 USC 102, it exists in a single piece of prior art. So 35 USC 102 would be basically it's copying something else already out there. It can be found in another reference. You try and claim a spreadsheet, and you claim a bunch of cells, which are each one you can enter data and calculate from one to the other. It would have made a really cool patent. It was never patented. VisiCalc didn't think they could get a patent, but they probably should have tried. This back in the 80s. Then, anyway, that would be a 102 rejection because it's already out there. 103 rejection, it's obvious from combining multiple pieces of prior art. So now you try and patent something which is, say, a spreadsheet which also shows dancing cats. So they're going to say, well, a spreadsheet is out there thanks to VisiCalc and Lotus, and where do we go from there after Lotus? I don't remember, Excel and whatnot. Then, dancing cats have been out there for a while, so combining the two is obvious unless you have some sort of new and obvious reason. What's the rationale for combining them that's different? If you patented, say, a method of, I'm not going to invalidate someone's patent application who goes and files this, probably not. You say a method of every time the person gets a correct answer in their spreadsheet calculation, it turns out what it's supposed to be. It makes a dancing cat which turns at a rate of speed related to how correct their answer was. Maybe that's a patentable method. Probably is. I can get that patent for you, except I just said it's my idea, and it would be 35 USC 102F, plagiarizing someone else's idea, but barring that. Okay.
XSMCLE control number 6-13-13.
And 112 is you didn't meet the enablement requirement. It doesn't really disclose everything, or inadequate disclosure. You don't have support for a term in your claim that you used in the rest of the application. Okay, one note on the expedited filing system. There's actually two ways to do it. I'll only discuss the one which makes sense. One was put in under the Bush error, which makes no sense. Nobody does it. Involves tremendous amount of disclosure. Actually, I shouldn't say nobody does it. Small number of practitioners did do it, but it requires a tremendous amount of disclosure, lots of work, lots of expense. The cheaper way is what the Patent Office said, hey, forget that. Why should the attorneys be paid tons of money to do our job? Initially, that was the Bush error expedited procedure. We'll let the patent attorney make tons of money doing our jobs, doing it extremely extensive, all sorts of disclosures, and filing the patent application. Patent Office said, no, forget that. Just pay us, depending on the income of the person who's filing, about $1,200, $2,400, or $4,600 roughly, and we'll guarantee examinations within 4 months. So they said, no, the government's going to make the capitalist system work for the patent office budget. So if you pay a lot more money, you can get expedited exam. I should also mention on the filing fees I gave are micro entity versus small entity. For a large entity, the fee is now $1,600 for filing. It's $1,600 if you're a large entity, if you have a company over 500 employees. I have, I think, 2 of those now. They're pretty cool clients to have because, hey, they got money to pay you, but the fees they pay the government are much higher. So the general rule is large entity pays $1 for every fee, the small entity pays 50 cents of every fee, and the micro entity pays 25 cents of every fee. Okay, other eventualities which can happen. So some of these include restriction requirements, more than one invention, choose one. They give these ridiculously frequently. If you have a method of shaving a cat and a device which shaves the cat, and it's really claiming the same things, they'll say, nah, we don't want to do 2 of those, select one to examine, and that's what they'll do. A divisional, more than one application based on the same disclosure. So that's after restriction. You'll sometimes have to file a second application. based on the first one with different claims, continuation once they reject you and you want more chances, and appeals to appeal a case if you can't get anywhere with the examiner. I do this sparingly because it's expensive. You're going to make the examiner mad, and you generally have to work with them again. And, those are the two reasons. I had one case, examiner insisted on interpreting the word limited to as related to. And it was a plain English word. Limited to, if I say limited to 50 miles an hour, it's limited to 50 miles an hour. It doesn't mean 60 miles an hour because 60 is related to 50 because they both have a zero in them. That was more or less how the examiner was interpreting it, and I couldn't get anywhere with him, I couldn't get anywhere with the supervisor, appealed the case. That brings us to the next topic, foreign filing. U.S. patent protects you only in the United States. Going back to my mafia analogy, United States, pretend they're like the Lower East Side Mafia. They control the Lower East Side. You want protection in the Upper West Side? Fine, no problem. The Lower East Side Mafia has contracted with the Upper East Side Mafia. They said, we'll make it easy for you. We'll streamline the system so you can protect it. You can just show us your protection over there, and we'll protect it over here. Only catch, you got to pay more money. Each mafia, each area each geographic territory you want protection, you pay for it. It's commerce in action. Works the same in mafias as in government. So, again, I love the United States government. Don't get me wrong. I just find the analogy very apt. So, the way it works here is that there's treaties with, I believe, 181 countries. 1 year from your earliest filing date, you file in those other countries, and each country has its own fees and rules, and you have an attorney in each country who works with you. Generally, me as the attorney in the United States, I work with the attorneys in the other countries. So I file often in Canada for obvious reasons. They're just above us, and we love their, maple syrup and politeness and clean streets and how they achieved all that, but whatever. So we file the patents there in Canada, and the fees are also very reasonable in Canada. And then, because we paid the protection fee in Canada, you can get protection in Canada. You can file directly, say from the United States to Canada, or you file what's called the PCT, Patent Cooperation Treaty application, which streamlines the process even further, but costs a ton more money. It's worth it if you're filing tons of patent applications. And that brings us to eventually you get a patent. And the patent will have this nice certificate signed by the Undersecretary of Commerce, who is the person running the patent office. He's a Undersecretary of Commerce running the patent office. It's David Kapos right now. He's about to step down, I heard. And then you get this patent, and it protects you for 20 years. Well, kind of. Protects you for 20 years if you continue to pay the protection fee. There are maintenance fees. You pay the maintenance fees between the third and a half and fourth and a half year. Fee goes up between 4 and 4.5. Before the 8th or before the 12th year. And if you pay all those fees before the 4th, 8th, and 12th year, with 6-month grace period after and the fee window opens 6 months before, your patent will last 20 years from date of filing. Well, date of filing, because it used to be date of issue, then people gamed the system and they would just delay issuance for 20 years and suddenly their patent would pop up for windshield wipers, which had been out, because now they just want to go and crush the competition only once they came out and have 20 extra years. And they would keep filing continuation just to keep extending the life of their patent. So now it's 20 years from date of filing, so if you delay, you're losing term on your patent. Fix that problem, but it created another problem, and that other problem is simply that patent office causes delay. Backlog can be years in some art units for some type of patents that you file. So if the patent office delays, the theory is it should take 3 years to get a patent. If the patent office delays more than that theoretical 3 years, then you get extra term on your patent. I had a crazy case where I had 2 patents issued the same day, same client, same technology, but 2 different aspects of it that we patented. One was filed roughly 2 years before the other, and issued the same day. Because one of them had a 2-year patent office delay, the other one had no patent office delay, the one which is filed first lasts longer than the one that was filed later, because the patent office took, say, 1.5 years on the second one, and the theory is based on a 3-year theory, and the other one took 4.5 years, so they gave him that extra 5 years, whatever it was, and they gave him extra time, so that earlier filed patent lasts longer than the later filed patent. Go figure. Anyway, that is my presentation for today. Please feel free to look me up, don't send me hate mail, ask me questions. Let's talk about patents, abstract concepts, whatever it is, trademarks. This is what I do for a living. I'm patentlawny.com. You can reach me at 973-685-5280 or 212-316-0381. And if for no other reason, check out my website to see the cat that Mark Cuban drew me at patentlawny.com. Thank you very much for listening. Goodbye.
Copyright XSMCLE. All rights reserved.